Honorable Senators, the High Court fails to recognize that the Senate did not determine that an adjournment could not be granted. Indeed, the vote on the motion on the request for an adjournment was precisely on whether to grant the adjournment or not. The Senate, as the impeachment court, decided not to grant the adjournment request in these particular circumstances of the day because of the absence of evidence or good cause presented to it. This is standard practice for any judicial or quasi-judicial body. The Senate, like any other judicial or quasi-judicial body, including, for that matter, the High Court itself, only grants adjournment on good reasons. The discretion to grant an adjournment is not automatic. It must be exercised judiciously, balancing the right to a fair trial with the constitutional mandate to avoid unnecessary delays and dispose of cases judiciously. In the matter at hand, it is probably true to say that no court, in the circumstances the Senate found itself in, with an application for an adjournment entirely devoid of any supporting evidence on its merits, would have granted an adjournment. An applicant for an adjournment must provide cogent, credible, and convincing reasons why a trial should not proceed. The court gravely misdirects itself on the import of the rights of an accused person under Article 50 of the Constitution by failing to recognize the right to be present is a right of the accused person and not an obligation. An accused person who, having had the evidence adduced against him and had an opportunity to challenge it in person or by advocate on cross-examination, chooses without a good cause shown to absent himself from further proceedings, whether with the aim of paralyzing proceedings or otherwise, for any other reason, cannot benefit from the provisions of Article 50. No court properly interpreting the Constitution should find that the right to a fair trial has been violated because an accused person has chosen to absent themselves from his trial or any part of it without providing sound reasons or evidence for that course of conduct. For these reasons, a key part of the appeal to be preferred by the Senate will center on this plainly erroneous finding of the High Court. Honorable Senators, having reached the foregoing erroneous finding, the Court then proceeds to issue orders that have recited above, which the Senate will, among other matters of fact and law, also be challenging in the Court of Appeal. The order for constitutional damages of KSH50 million to His Excellency Gachagua being predicated on erroneous findings and regulatory orders of the court will similarly be challenged. Honorable Senators, the Senate is first to pledge fidelity to the supremacy of the Constitution and all the inbuilt principles of the rule of law and separation of powers. In similar vein, the Senate will robustly stand in defense of the Constitution from derogation and violation from any quarter, not least the courts of law. The Senate must do this not for its own sake, but because it is the duty of every person and Article 3 of the Constitution to respect, uphold, and defend the Constitution. I thank you.
Anthony Mrima said himself, without being prompted by the Council of the Senate, Mrima said, it must be emphasized that the Senate is not a mere conveyor belt for matters originating from the National Assembly or any other entity. He went on and added that it is a revered house vested with autonomy and empowered to make decisions by way of resolution, and therefore the Senate retains the discretion to determine whether to accept any motion or petition for further deliberation. He must be reminded that when he was thinking rationally, as I have quoted him, how was he expecting this Senate without any application from Senior Counsel Paul Mwite that his client had fallen ill? How, without evidence, did he expect the Senate, with the kind of discretion that he has
1 minute to conclude.
In conclusion, without that, for us to then agree with them, are they saying if somebody facing charges of robbery with violence flashes and dashes out of court, and his lawyers say, we don't know where he is, we don't know where he's going, then the judge immediately says that we discontinue the proceedings? No, Mr. Speaker. Mr. Speaker, we have gone to school properly. The purpose of university education is for you to have organized thinking, critical thinking, the capacity, Mr. Speaker, to see the difference between right and wrong. The judges were wrong yesterday on this one. Thank you, Mr. Speaker.
Senator Kajwang.
Thank you, Mr. Speaker. Mr. Speaker, Paul Mwite was behind me here. I was seated very closely to him when he told us a ridiculous thing that he does not know where his client has gone. And Mr. Speaker, in the same breath, Paul Mwite was telling us he needs time. We gave him time as a Senate to go and look for his client. He came back and said he does not know where his client is. And Paul Mwite is a senior counsel, Mr. Speaker. He used to be chairman of our law society when we were younger and in active practice. So, Mr. Speaker, we found this extremely ridiculous. There is no way that we can reward misbehavior in court proceedings. We cannot reward that, Mr. Speaker. I fully support, Mr. Speaker, that we should file an appeal in proceedings, whether they are quasi-judicial or they are proper judicial. If you choose to run away from those proceedings, you forfeit your rights. You forfeit them by choice. And Mr. Speaker, the videos are all here. We must not create the impressions amongst Kenyans that Mr. Gachagwa's rights were violated. There was no violation. He chose to run away. That's a fact. He ran away, didn't tell his lawyers, didn't tell anybody, and we must tell the truth as it is. He knew that he was coming for cross-examination. When he was saying his case, it was okay. But when he knew that you are going to ask about the family affairs, ask about the violations that were being complained of within the family, he knew, Mr. Speaker, and he ran away. He ran away from this court, Mr. Speaker. He ran away. He should not tell Kenyans or the court tell us that we didn't give him a chance. He simply disappeared. And the court must be fair to this Senate. This Senate gave him all the opportunities, Mr. Speaker. We must appeal these decisions, and Kenyans must be told the truth. Possibly, Mr. Speaker, these clips must be replayed on KBC or any other channel so that Kenyans can know the truth. The judges were totally wrong on this one, and they must be told on their faces. They were wrong. You cannot, even them, if an accused person runs away from your court, you don't stop proceedings. You proceed because he chose to forfeit his rights.